Welcome to Motoring Defence Solicitors. My name is Neil Sargent and I've been specialising in defending road traffic cases now since 2008. If you're watching this video, I assume that you've either been charged or you might be about to be charged with failing to provide a specimen for analysis. You might feel worried or anxious about the proceedings moving forward and what will happen to you, but hopefully this video can provide you with some useful information and insight so you can make a much more informed decision about what to do next. If you would rather just speak to us directly, then please feel free to give us a call, or alternatively, fill in a callback request form on our website and we can arrange an informal chat about your case. We can go through the options with you completely free of charge. If the police suspect a motorist of committing an offence related to drink or drugs, they can, if they follow the correct procedure, require a motorist to provide them with a sample of either breath, blood or urine. This offence of failing to provide arises when the motorist fails or refuses to provide that sample without what is known as a reasonable excuse. This offence is often one that causes some motorists to feel particularly aggrieved, especially if they think that they're being asked to provide a sample when they don't think that they've done anything wrong. But when looking at cases of this nature, one of the most important things to consider is the reason behind the failure or the refusal. There are several things that can contribute to a reasonable excuse for failing to provide, such as breathing difficulties, including panic or anxiety. You might have tried to give a breath sample but genuinely been unsuccessful. This might be because the officer's given you poor instructions on how to blow into the device. It could also be a problem with the device itself or the mouthpiece, so there are several factors that can contribute to a failure to provide a breath sample. In the case of a blood sample, having a phobia of needles might be the reason you weren't able to comply, and if you were asked to give a urine sample, you might be one of these people that find it difficult to urinate either in public or when under certain pressure. This list is by no means exhaustive, but hopefully it gives you an idea of the types of things that may contribute to a failure to provide and a reasonable excuse. When speaking to clients, I always say, if you genuinely tried to provide a sample and you just couldn't do it, then chances are there's something else that explains the failure to provide, which may give you a reasonable excuse at court. Even if you didn't genuinely try to provide, there may still be ways to defend your case if the police didn't conduct the procedure correctly. The procedure that they need to follow can be quite complex, so we would also recommend that you speak with us and we can discuss the specifics of your case. Failing to provide is one of the more serious offences that a motorist can face, and the penalties are similar to those imposed in drink driving cases. Whilst most people already know that drink driving attracts a 12-month disqualification, many might be unaware that this also applies in cases of failing to provide, and that there are also a range of different penalties that the court can impose. Depending on how serious the case is, you may be facing a much longer disqualification, a community service order, or even a prison sentence, so we always recommend that you get some advice from a specialist as soon as possible. If you are dependent on your driving licence, or you need to avoid a conviction for any other reason, we can assure you that we leave no stone unturned when we scrutinise the prosecution's evidence against you. And whilst no firm can ever guarantee a particular result, we can always guarantee that if there is a way to defend your case, we will be able to find it once we look at the evidence. Most people who face a charge like this assume that they've got no choice other than to plead guilty at court, and this is simply not the case. We've specialised in defending allegations exactly like this for over 15 years, and we are proud to say that we've got a very high success rate. We've helped countless motorists across the country defend their case and keep their driving licence intact. So if you are facing this allegation, please do feel free to give us a call. We can help you understand the options and discuss any potential defences that you may have, so you can make an informed decision about what to do during the next steps of your case.